Hello, law students and legal practitioners. Today, we will analyze the case of spouses JG and AG versus spouses CP and CC. NPC case number 23-036 decided by the National Privacy Commission in 2023. Let's begin. Doctrine of the case. Unauthorized processing under Section 25 of the Data Privacy Act of 2012 is committed when personal or sensitive personal information is accessed, obtained, or disclosed without the data subject's consent and without lawful basis, even if the information is later used in judicial or quasi-judicial proceedings. The exception under Section 13(f) of the DPA for the establishment, exercise, or defense of legal claims does not apply where the personal or sensitive personal information was obtained through unauthorized or illegal means. Lawful purpose in litigation presupposes lawful acquisition of the information used. The rule on exhaustion of administrative remedies before the NPC may be waived when the alleged violation involves a serious breach of the Data Privacy Act, poses a risk of harm to the data subjects, or where no plain, speedy, or adequate remedy remains available, especially when the unauthorized processing has already occurred and cannot be undone. Here are the facts. Spouses JG and AG, complainants, were respondents in a criminal complaint for syndicated estafa filed by spouses CP and CC, respondents, before the National Bureau of Investigation, NBI, which was later endorsed to the Office of the City Prosecutor of Quezon City and docketed as NPS Docket No. INV 20B01419. During the preliminary investigation, respondents submitted a joint and consolidated reply affidavit in which they attached and relied upon an affidavit of desistance with mutual release and quitclaim executed by a third party, AL, in a separate syndicated estafa case against complainants, in which respondents were not parties. Respondents openly admitted in their pleadings that they were able to obtain the affidavit of desistance through the assistance of good-minded persons with access to NBI records. Complainants alleged that the affidavit and related records contained their personal and sensitive personal information, including their identities, addresses, marital status, and details of criminal proceedings previously filed against them. On the 14th of March 2023, complainants filed a complaints-assisted form before the National Privacy Commission, alleging violations of Sections 25, 28, 31, and 32 of the Data Privacy Act. They asserted that respondents had illegally accessed, processed, and disclosed their personal and sensitive personal information without consent or lawful basis. Respondents countered that the complaint should be dismissed for failure to exhaust administrative remedies and for failure to implead the NBI as the alleged personal information controller. They further claimed that the disclosure was lawful under Section 13(f) of the DPA since it was made in connection with a legal proceeding before a government authority. Here are the issues resolved by the National Privacy Commission. Issue 1. Whether the complaint should be dismissed for failure to exhaust administrative remedies. No. The rule on exhaustion of administrative remedies does not apply. Under Rule 2, Section 2 of the 2021 NPC Rules of Procedure, the Commission may dispense with the requirement of exhaustion when the complaint alleges a serious violation of the DPA, involves risks of harm to data subjects, or when no adequate remedy can be provided by the respondent. The Commission ruled that complainants sufficiently informed respondents of the alleged data privacy violation through their joint rejoinder affidavit in the criminal case. Moreover, even assuming non-compliance, exhaustion was properly waived because the unauthorized processing had already occurred and could no longer be remedied, and the alleged acts posed risks of harm such as identity fraud and misuse of sensitive personal information. Issue 2. Whether respondents are liable for unauthorized processing under Section 25 of the Data Privacy Act. Yes, respondents are liable for unauthorized processing. Section 25 of the DPA penalizes the processing of personal or sensitive personal information without the consent of the data subject and without lawful basis. Sensitive personal information includes information concerning criminal proceedings and their disposition. The Commission found that respondents processed complainants' information by obtaining, attaching, and using the affidavit of desistance in their pleadings. The document clearly contained personal and sensitive personal information. Respondents admitted acquiring the document from unauthorized sources within the NBI and failed to show any lawful basis for its acquisition or use. The claimed exception under Section 13(f) was rejected because lawful purpose in litigation does not legalize illegally obtained data. The processing violated the principle of legitimate purpose and constituted unauthorized processing under Section 25. Thank you for listening and happy learning. See you again for our next case discussions.